Am I audible?
Yes, sir.
Yes, good evening, everyone. Am I audible there?
Yes, sir. You're audible, sir.
Okay, very well. I think then we can just wait for a few more minutes.
Yes, sir. Just 5 to 10 minutes we'll wait, sir, and we'll start with the session. Just students are joining, sir.
Sure, certainly. We'll wait for 5-10 minutes. No problem. Thank
Yes,
you.
sir. And sir, Harpreet, sir, welcome on behalf of Bharati Vidyapeeth. It's
Thank you. Thank you
having
so
you.
much.
So we'll just start with the inaugural session in just 5 to 10 minutes, sir.
Certainly. Thank you for the update. Thank you so
Okay.
much.
Thank you, sir. Yeah. welcome all. So we'll start with our session. Sir, Harpreet sir.
Yes, yes.
Shall we
I'm
start,
available.
sir?
Thank you. Yes, yes, we shall. Thank you.
Okay. योग कर्म सुकौशलम धर्म मार्गे स्थिर मन न्याय संवाद संयुक्त विजय पथम प्रदर्शयेत। अर्थात जो व्यक्ति अपने कर्म से योग और कौशल्य को अपनाता है, धर्म पर स्थिर रहता है और न्यायपूर्ण संवाद से जुड़ता है, वही सही मायने में विजय की राह दिखाता है। संदर्भ यह श्लोक आज के विषय विजय पथ को न्याय से जोड़ता है, क्योंकि विजय का मार्ग केवल दावे से नहीं बल्कि कौशल, संवाद और सामंजस्य पूर्ण लिए हुए न्याय संगत निर्णय से प्राप्त होता है। With this guiding verse from Gita, I extend a warm welcome to everyone. At this juncture, I would like to extend welcome to our Dean and Principal, Dr. Ujwala Bendale ma'am, Vice Principal Jyoti Dharam ma'am, IQSA Coordinator Vidya Dhere ma'am, and my respected colleague, Dr. Shubham Tripathi sir, without whom this program would not have been possible. A warm welcome to today's resource person, Harpreet Singh Pun sir, partner of Shri Ram Law Office. Sir is a qualified arbitrator, qualified mediator, and CS qualified. It is an honor to have you. It's an honor to have you, sir.
Today marks the fourth day of our journey, Vijaypad, from claim to victory. Arbitration, in its essence, is not about defending the other side, but about elevating the process of justice in a way that both parties find resolution and peace. Just as Gita reminds us that a true battle is within between harmony and conflict, arbitration reminds us that victory lies in fairness, in understanding, and in resolution beyond adversarial struggles. May today's deliberation guide us through the path where the claims are transformed into victories of justice, truth, and equity. Thank you, everyone. With this, we start today's lecture from the Harpreet sir.
All right. Thank you. Thank you for the wonderful introduction. And I think the beginning itself was wonderful with shlokas and giving the insight of how to try to resolve the dispute. Shubham and the team who has given the introductory part. Right. So I would quickly, we have to switch on the video. Is it, or how it's going to be? All of you can switch. Okay.
Yes, ma'am, sir.
Right. Okay. Am I visible and audible?
Yes, sir.
All right. Okay. Right. So, first of all, thank you for wonderful introductory session. And thank you to the institute, principal and vice principal, and all the faculty in charge who have arranged this series. And not to forget our friends, each and every one of you who are a part and online you are present here to attend this seminar or a discussion which we are having it today. So now, before I begin the topics on the arbitration and the subject matter, now one thing I want to understand is how many of you are actually have covered the topic of arbitration in your curriculum, or it's open for everyone? Who are the participants? Is it open for all?
Yes, sir. It's open for all, not only law students, but open to all whoever wants to get the glimpse of arbitration.
Excellent, excellent. Very well. Thank you. Thank you.
Yes.
Now, why this clarity I want to know, wanted to know, because we think that arbitration law is only meant for advocates, counsels, or the judiciary, right? That's not the case. So whenever we are learning any law, so you got to pay attention to this. When we are learning any law, remember this: laws are made for all of us. Okay, be it an architect, doctor, engineer, professor, businessman, advocate, whomsoever, because time and again you would have heard this phrase that ignorance of a law is not an excuse. So it's obvious. What does that mean? That the law which is made, it is meant for everyone, each and everyone. Nowadays we are seeing there are a lot of issues coming up before the different benches and the high courts or even the Supreme Court. We are having an issue of dogs we would have followed right now, right? So see, every matter has gone its own uh, methodology of adjudicating the dispute. And arbitration is such a diversified field, if I may call it, because this field is trying to reduce the burden in the court. Now, before I get into the arbitration, I would just want to make fundamental basic for everyone. That was the reason I asked who are the participants for the present course, because somebody who's not coming from a legal background or the law background, he or she should be able to understand what we are discussing, right? So try to understand this. Like anybody has a question in between, you can raise hand or you can unmute yourself. Feel free to ask the queries. Okay. Now we have constitution, all of us know it. So treat the constitution as mother. Okay, that is the mother of all the laws. So we have commercial laws, we have contracts, we have law of contracts, we have Indian Contract Act, we have Partnerships Act, we have Companies Act. You can talk about the Hindu Marriage Act. You can talk about the Arbitration Act, and you can talk about the new laws. You can talk about Mediation Act. So now we have got Mediation Act also in our judicial system. Now, one thing is for sure, there will be multiple laws which are in place. There could be a central laws, there could be a state laws. Like we have Maharashtra rent control, right? So it's a state enactment. We have a Maharashtra court fees. So it's a state enactment yet again. So try to understand that there are a bunch of laws which are the working in a different area, and the scope is different. And for that, you got to have a clarity which is superior or which is inferior. So majority of the time, people feel, or the laymen feel, that the central laws are superior, or if there are two central laws, which will become the superior law. So try to understand that. As I told you, just have this mindset. Okay, we have a constitution, right? So constitution is the mother. So any mother or father, will they discriminate between son or daughter, or brothers or sisters? So these laws, just imagine, these laws are son and daughters of constitution. And no law, like the state law or the central law, I'm not talking about the union list or state list, not that way. I'm just talking about in general. Have an understanding like this. All the laws in the eyes of constitution, they are similar or they are same. Nobody is superior or inferior. So they are equal in nature, right? Now we have got bunch of laws, but still we see that there are a lot of hardship the parties feel. Now you come across the issue of commercial disputes, you come across matrimonial dispute. Sometimes you have disputes amongst nations also, international level. So there you have another charter. There are a lot of international treaties which are in place. Now currently you can see, you got to link the law with the practicality, right? Like I'm sure, how many of you are using the I'm sure most of you must be using that. How many of you are using the social networking sites, or let us say apps like Big Basket, Zomato, Swiggy, right? All of you must, yeah. So Shubham uses, okay, so he gave a thumbs up. Okay, there are multiple apps we use. Now this Zoom is also another app and the software, right? So whenever we use any app, software, or any technology, right, we always sign terms and conditions. It's called e-contract. So when we sign the agreements through the physical, the hard copy, or the online modes, right? Now what happens is we agree that we have read the terms and conditions. And you can always check next time. Now, these are just examples I would like to highlight. I'm not promoting or defaming any company, but what I'm trying to suggest is that you have these bunch of apps which we use on a daily routine, the Google, the Facebooks, or Instagrams, WhatsApp, right? So all these apps we use on the daily routine. And next time when you're going to use, just go to their settings and just read terms and conditions. I'm sure many of us will not read that, but at least try to read about the dispute and courts. And you'll find out one thing which is common amongst all these apps or the softwares, are they are trying to avoid going to courts, right? They don't want to go to court. They want to resolve the dispute outside the court. And one of the methodology of resolving the disputes outside the court is an arbitration. Now, the word itself says, so you don't have to be a lawyer to understand that. As a layman, any law you read, any word you read, the preamble or the short title, just read the heading and understand the concept. Why this act has come? Is it an act to consolidate, amend, modify? Now, I'll make it very simple for the layman understanding, considering the participants in mind, right? Now, we're talking about alternative dispute resolution, ADRs, which we quite often use, alternative dispute resolution. Why you want alternative? This question should come to your mind. Why alternative dispute resolution? We are talking about courts. Now, courts are meant for people, for public, right? And why is that the sitting judges, the Honorable Chief Justice of the High Courts in the past and present, and even the justices of the different high courts, time and again, they are promoting the parties to resolve the dispute through ADR. Why is that? Have you even thought about it? Yes, I want little bit more interactive, right? If you'll be interactive, it'll be interesting. So feel free to ask any doubts or just chip in. Okay. And any insight about this question? Why is that the court is asking the parties without searching from your search engine? Okay, don't give me Chat GPT answers or Google answer behind. I want the real, raw, authentic answers or suggestions. It could be right or wrong. We are not concerned about right or wrong. I just want to understand the analogy. How far you guys are following it in the practical world? Why is that? Yes, please.
So one of the reasons could be the pendency of cases in our courts.
Right. Yeah, that's Priyanshi, right? Thank you, Priyanshi, right? One of the reasons, what our friend has suggested, she said, because there are a lot of pendency in the course, in the courts. There are a lot of pendency, a lot of matters are pending. And the general public has this idea that what we get in the court probably are dates. Tariq pe tariq in the past from decades, people have heard this phrase in the reels and the shows. Yes, add to that, one of the reasons are like she has suggested pendency of the case. So there are some text also. Okay, chat. The courts are overburdened. The courts are overburdened to reduce the burden. Yes, Samruddhi, yes, that's correct. To reduce the burden, yeah. Why the burden, by the way?
So I think there's one more reason
Yeah,
right off
yes,
the top
Raj.
of my head. I think.
Yes.
Hi. Hi. Good afternoon, sir. Yeah, it could be that the system is too adversarial, and people and arbitration actually is more. Can you hear me?
Yes, we can hear you. Go ahead, please.
Yeah. If we go to a regular court, it becomes too adversarial, and then arbitration is more friendly and it actually aims to resolve the dispute amicably.
All right. Thank you, Raj, for your inputs. So our friend Raj, he suggests that more friendly atmosphere you get in the arbitral proceedings. Okay, I'll hold on to your thoughts. Yes, thank you for your inputs. Anybody else?
So students are also interacting on the chat box.
Yeah.
Anjali
I
is
can
saying lesser
PD.
number of courts and judges.
Yes. PD and lesser expensive resolution by ADR, lesser number of courts and judges. Okay, right. Quite common, quite usual, and spot on suggestions by all of our friends, right? Now, to highlight a problem is more important, because if you know what is the problem, then you can come to the solution. Now, few of the suggestions are pendency of the cases, lack of strength probably in the judiciary you're talking about, and then we're talking about arbitration as a more friendly approach methodology of resolving the dispute. Now, these are the common grounds that actually request, I mean, which the judges are trying to send the matter to arbitrations and the ADR methodology, right? These are the common grounds. But try to understand that why dispute arises. I don't want legal jargon. Why dispute arises most of the time? Arbitral, you get more. Who is that? Shankar. Okay. Arbitral, you get more mutual result than one side result in conventional court judgment. Right. So you very well. Okay. So Shankar has suggested that it's a like a win-win situation. Whereas on the contrary, before the judge, in the courtroom, one party wins, other party loses. Okay, so that is your idea. It's interactive and good suggestions by many of our friends. Now, you got to understand that first of all. Now, this I quite often use in most of my lectures and the discussions among the friends in the colleges and the conferences and the ODR methodology also. Like most of the time, we have to have one golden thumb rule which you have to understand that as a litigant, as an individual, as an advocate, or also as a judge, you have to have this clarity, right? That is which court you will go, which forum you will go, who will be the parties, and what relief you are seeking. If you have a clarity about these three things, half of your matter and half of your problems are solved, right? I'll repeat it again. You got to have a clarity on three things for sure. Number one, which forum to choose. I'm not talking about court. I'm using the word forum. It could be authority, it could be an authority, it could be a commission, it could be a court, right? There are a lot of tribunals, there are a lot of commissions, like consumer commissions are there, NGT, DRT. So there are a lot of tribunals are also in place. So first thing first, you should know which is that forum which is gonna give me the remedy. Then you ask yourself the question, okay, I am the party or I'm representing a party against whom I have to file a case. The second thing which I often repeat is, second thing is identify who will be the parties to a complaint, to a petition, to a tribunal proceedings, etc. And last thing, the reliefs, the prayers which you are seeking. If you have a clarity about these three uh, things, you will not go wrong. You will never go wrong. And the chances are you're in a better position to provide justice to your client. And even as an arbitrator or as a judge, you should always have this clarity. Have this clarity that here are the litigants who are coming before me. Do I have the jurisdiction to pass? Do I have the authority to pass the order? As a layman, I'll just give you this example. Now, when I came to Maharashtra, the first item I had, Maharashtrian dish, was thali peet. So I'll give the example of thali peet. And majority of you may know about it, right? So you will get thali peet usually in a restaurant. Like again, I'm not promoting or defaming, just giving the example. Vadeshwars or other places you get thali peet or sharwari. Will you get thali peet at Domino's Pizza or the Pizza Hut or McDonald's? As of now, no. If they become creative, then I don't know. But as of now, you will not get these items there. So likewise, so it sounds like switch to different language. Okay. So likewise, you have to have a clarity what you are seeking. That's what we call it as a prayers or reliefs. And as a judge, as a party, as an advocate, as an amicus curiae also, you should know these things. That's why I quite often say, if you have a clarity about these three things, half of your battle is solved. So sometimes parties are not added. Sometimes the parties are fighting before a wrong forum. Like sometimes in the past, we have seen few students you would have read in the judgment also, directly approaching the high courts or the Supreme Court. That's a violation of fundamental right, environmental issue. So please grant me the compensation. Then Supreme Court said, please, High Court said, don't waste your time. Don't build up your CV. There is an NGT, the National Green Tribunal. You have to go there and fight the case. So, these are the basic examples which will give you clarity about the importance of these three key ingredients, which I quite often repeat. Now coming back to our discussion about arbitration, as few of our friends have suggested to reduce the burden in the judiciary, the judiciary is burdened with a lot of matters. And side by side, you want a atmosphere which is more friendly. Now, how many of you have been into the courtrooms? Let me ask you directly. How many of you have been into the courts for the court observation or in the past. I'm talking about trial courts. I'm not asking about Supreme Court, and I'm not asking about high courts. Okay, there are a couple of thumbs up, right? Now, okay, thank you for your responses. Now, so I will repeat few terms and the statements which are made by the sitting judges and the honorable justices for different high courts and also of the Supreme Court, that it is the trial court which deserves more credit. Now, earlier, sometimes in the judgments or in the petitions or the applications, parties used to write the learned lower court. So they have said, don't use the term lower court, you can use it as a trial court. But what I'm trying to focus upon is you're talking about judiciary, you're talking about an individual, she or he is going to pass the judgments, orders, or decrees, right? Some order they're going to pass. And majority of the time, what we find, most of the works are done in a trial court. And most of the high courts or the Supreme Court matters are arising from a trial court. Now, for example, the judicial system, for all of us who are, many of you, few of you may not be from the law background. So we have a hierarchy of the court, right? We directly cannot approach the high courts or Supreme Court. There is a due process. You, like, for example, you have to have uh, 10 standard, 12 standard, then you do bachelor's, right? All of us have followed that. Directly, nobody has joined the bachelor's course. So likewise, in the Indian judicial system also, we have hierarchy of the courts. So we have city civil courts or junior division or senior division, which is followed by district court, and then we have high courts, and then Supreme Court. This is the hierarchy of the court. Likewise, on the criminal side, we have judicial magistrate first class, second class, sessions court, and then we have high court and the Supreme Court. But we're gonna stick ourselves to civil side because arbitration is dealing only with the civil disputes. Now, this is a key point which you have to remember. Now, all of you got clarity on the hierarchy of the courts. I'm building the fundamental basis basis for everyone, right? You got the hierarchy of the courts in India, all of you. Is there any chat box? Yes and yes. Okay, great. Right. So now the question is, when you're talking about, thank you for your response. When we're talking about pendency of the cases, the reasons which few of you have suggested, there is a lack of appointment or pendency of the cases, right? Now, who appoints judges? Now, who appoints judges? Anyone? Can you give me the answer?
The Chief Justice of India.
Chief Justice? Okay, good suggestion. Okay, just give me one answer then. Now, how do I make it? Okay, let me ask you this. Now, can all of us become judges as of today? No, right? President. Okay, just skip that. But I'm just coming back to very basic understanding for no. There are a couple of answers, right? So basically, you got to have some qualification, right? You got to have some qualification to become a judge. Like there will be age, citizenship, XYZ, and then you're talking about examination pattern. Now, Supreme Court has recently said, by the way, right? Supreme Court has said many of our friends probably maybe unhappy or happy about it. I'm not sure, but they have made compulsory. 3 years if you want to write an examination to become the judge, then you should have a 3 years of practical experience, right? Like this is a welcome move because obviously we got to have a clarity on the practicality along with the academics, right? But one thing is for sure, I'm sure all of you agree that there is a procedure to appoint the judge, right? Now, unlike the judicial system, collegium, okay, yeah, judges appointing judges, that was also there in the past. Thank you. Now, can all of you become an arbitrator today? This is my second part of the question. First part was about judge. Now I'm asking you a simple question. Can you all become an arbitrator today? Yes. Okay. You're in the chat box. You are mentioning. Okay. Yes. Yes, ADR. Okay. State government appointed judges with consultation of high courts. Okay. Yes, I want more answers. You can unmute also if somebody wants to add up. Yes. Okay. Right. So yes. Yeah. So I think majority of you have got it right. Now, got to understand this. Now, to become an arbitrator, now we're talking about arbitration as a core subject for our discussion. Now, remember this: judges are appointed by due process, right? There are some qualifications which are prescribed. But to become an arbitrator, you don't need any specific qualification, right? It's not mandatory that you should clear the examination or there should be some parameters for that. No, the basic parameter is you should be neutral, you should be unbiased, and you should treat the parties equally, fairly. So we have done a lot of arbitral proceedings, and we have also participated in a lot of arbitral proceedings, wherein you'll find out and you'll be amused to know that majority of the times there are arbitrate proceedings or the arbitration proceedings wherein the arbitrator was not from a legal background. You know, somebody was a fashion designer, somebody was a doctor, somebody was an engineer. So not only a lawyer or a retired judge can only be an arbitrator. That's not the case. Like Justice Nariman had, I think, during his tenure, when he was the Supreme Court judge, that time he had given a criticism, and there was a schedule which was added in the Arbitration and Conciliation Act. So we have an act, the Arbitration and Conciliation Act, that governs this entire arbitral proceeding. So there, a schedule was added to become an arbitrator. What are the qualifications required? Like, for example, to become an engineer, what are the qualifications required? To become an advocate, what are the qualifications required? So you become an advocate after clearing your 3 years or 5 years course, and then you choose a state bar council, and then you write an examination which is called All India Bar Exam, and then you get a certificate of practice, so on and so forth, right? So there is a certificate of practice. So likewise, a schedule was added by the government, and then they prescribed the qualification required to become an arbitrator. I think 10-15 years or so. To become an arbitrator, you should have that many years of experience as an advocate, cost accountant, company secretary, right? So that was heavily criticized because, see, we want India to become the hub of arbitration. For example, all of us, those who are participating, it does not matter whether you have 6 months of experience, 12 months of experience, or 5 years, whatever it may be. If you have the quality to become an arbitrator or also a mediator, right? If the parties are giving their consent, then remember this: you are eligible to become an arbitrator or a mediator. But the consent is the foundation. What I'm talking about is when you agree upon the appointment of an individual to become an arbitrator or a mediator, the consent of the parties are important. Now, when I asked you a question, why dispute arises? Dispute arises because, see, a person's greed sometimes, that's why we have law of contract. So if, again, not all of us are from the law background, but again, there's something called agreements and contracts, right? So I give the example of e-contracts in the applications or the software which we often use on a daily basis. Those are the e-contracts. Now, contracts basically are enforceable. The basic crux of the law of contract, the Indian Contract Act, is the enforceability. Can you enforce it? You can make an agreement. You can make an agreement. But can you enforce it? If you can enforce it, that is a contract. For example, we get a lot of clients sometimes, like some of them wants to make some agreement regarding matrimonial dispute also. Like, can we make an agreement, like how to share our assets? So that is called prenup agreements, right? But that's not valid in India. So again, you got to understand the reasons why we are making this agreement. So dispute happens because the parties are unsure about the terms and conditions. And sometimes they're making an agreement, but which is not enforceable. So basically, sometimes the greed comes up of the parties, and because of that, the parties fight in the future. So it's always advisable to have in black and white, have in writing, get it registered. There are a lot of technicalities, but just understand this. To avoid future disputes, more disputes, it is always advisable to have everything in writing. It will be easy to prove it. And that's why you have got the concept of witnesses, etc., registration, so on and so forth. The point, what I was trying to make it is the judges are getting appointed by due process, and here is the methodology that a lot of answers which many of our friends have given, that why there are a lot of causes for alternative dispute resolutions, which is like pendency of the cases, burdens, and so on and so forth, and the lack of strength among the judiciary, because they also want quality judges, right? So they also have their own methodology of appointing, promotion, so on and so forth. So, but in arbitration, it is the parties actually who is appointing the arbitrator. In arbitral proceeding, that's the advantage. Now, I'm gonna club all the topics here, but I'm just taking it in a pathway because that's how the introductory sessions was made. Now, in arbitral proceedings, what happens is it is the parties actually who are deciding who will be an arbitrator. Now, the difference between the court proceedings and the arbitral proceedings, you got to understand that also, right? In the court, we don't say that, okay, I like a judge A, so I want my case to be listed before judge A. It doesn't work that way. But in arbitral proceedings, you can say, yes, I propose name of Miss B to be an arbitrator, or you mention in the agreement itself prior to the dispute, and both the parties agree. So it's the parties who are deciding. It's the will of the party. It's a private affair wherein the parties have got the freedom to appoint an arbitrator, right? So that's the advantage of arbitral proceedings. So again, coming back to the difference between the court proceedings and arbitral proceeding is, see, we also blame the judiciary most of the times, right? The litigants or the advocates. But I think majority of the times, once you're gonna jump into the real world, you'll understand that no, I'm an advocate. Again, I'm not trying to promote or defaming anyone. But then the advocates are also accountable for the same, because most of the time they are not prepared, they are not well versed with the facts or the law, and quite often they take adjournments. Now that's the problem between the two forums, or the differentiation, I should rather say, in the arbitral proceedings and the court proceedings. So in the court proceedings, now you have another procedural law, which is called the Code of Civil Procedure. Just got to understand that. Now, as per that procedural law, once the hearing begins, a party is supposed to take, and the Supreme Court has time and again also set up a precedent that only three adjournments shall be allowed. Only three adjournments. Now, that is on the text and that is on the procedural part, but the practicality is somewhere different. But yes, a sitting judge, she or he, if he or she is extremely sharp, he may put a lot of cost also and will make sure that the orders are passed on time. So there are many judges who are actually following that. Now, that adjournment, which is quite often happens in the court, that does not happen in the arbitral proceedings, because that is the only proceedings which is governed before an arbitrator on a scheduled date. For example, to those who have gone to the courts, some of you did raise your thumb. You have visited the courts. So you'll find that there are the cause list, the matter numbers, names are displayed outside the court. Even the high courts also have a displayed the screens and they call out the names, so on and so forth. Now, so what will happen is they have got 100 matters, 40 matters, 60 matters. And when you talk about the trial courts, see, they have got 200 matters, 400 matters. So there are a lot of numbers, right? And then you want them to pass the orders, they will hear your matter, and probably there will be cross examination. So how much time they can give for that? So that is the reason why even a sitting judge most of the time can exercise her or his power to refer the parties to arbitration. That's there in your in our code of civil procedure. Yet again, a lot of laws are talking about that, like section 89 of CPC will give an insight, the power of the court. If the party, if the judge feels that there are chances of settlement, then he or she can adopt all the methods of ADI, send the parties for mediation. You have seen the example in the past with Ambani brothers. When the Supreme Court also said, okay, try to resolve, you are the, contributing more GDP. And we have seen the recent example of Loda brothers also. So there are a lot of examples wherein there was successful ADR mechanism which has been used. So you see the beauty between, the court proceedings and arbitral proceedings. But one thing is for sure, we cannot avoid courts. Though I quite often say at the time of formation of an agreement or contract, we got to be careful about the different clauses when we make. Now, when you talk about this pathway, now at the time of coming together, the union, right? Parties don't think about disputes. And even if you talk about disputes, it's a very practical approach, right? That people will, if you mention about a dispute resolution clause or dispute clause in an agreement, sale deed or agreement to sale, partnership deeds, franchisee agreements, whatever you may call it. These are the bunch of agreements, leave licensing, so on and so forth. So if you have this dispute resolution clause, so quite often the parties are going to ask you why you are mentioning this clause. Is it not obvious that when you start any relationship, professional, personal, and that's why the prenups, by the way, because when you talk about the concept of marriage, so we don't have a prenup concept because it's secular, which we call it. Now, if you make a dispute resolution clause at the time of formation, quite often we find this difficult, used to find this difficulty, used to, I'm saying, not right now. We used to find this difficulty wherein the parties will suggest, why are we mentioning about dispute clause? We are not going to fight. We are the brothers, we are sisters, or we are college mates, and we're not going to fight in the future. So, see, the future is uncertain. At that, when you come together in the beginning, in the start, like I'm sure many of you would have witnessed at your near and dear one's place, home, etc. Right now, the many times we find that everything is a bed of roses. Everything is so smooth. We're never gonna fight. That's not the case. The fight can happen. The dispute can arise anytime in the future. So it is our role as a party to ensure that we are protecting both the interest. It cannot be unilateral, but both the interest. So we are taking care of the disputes for the future. So we incorporate that clause right now. Right? Again, the difference between the court proceedings and the arbitral proceedings you'll find out, or any of the ADR method is, see this court proceedings. Actually, let me just come back to the people, those who had, all of you can contribute. Like, how many of you actually has observed a court proceeding? Not just went there, case observation or something. No, you were there sitting inside and you have observed any cross examination or argument. How was your experience in short? I just want to know that much. Yes, please. Yes, anybody would like, any one of you would like to give your experience? Till then, I'll go to your chat box. Okay, these are the earlier messages. How was your experience? Those who had gone to the courts. Okay, you can talk about High Court also. But
Am I audible?
yes, you're audible. Yes, yes. Good evening, please. Yes, go
Good
ahead.
afternoon, sir. I'm Devu. I intern in a JFMC1, first class magistrate. Am I audible?
You're audible. You're audible. Yes. How was your
Okay.
experience?
Okay. So, from there, I witnessed a examination and a cross examination. While
Okay.
the examination was going on, I felt like the person who was being examined, his side was the right side. Like he was being beaten by someone. And then after that, he was cross-examined. And later I realized that he was the main reason that this fight even happened.
Okay.
So when
How,
I heard the cross-examination, my side completely turned. Okay, so that was
yes.
a very good experience from my
Good
internship.
experience. So what did you love the most about the court proceeding? I don't want to know the names of the parties, so you don't have to tell the name of the parties or the judges or the forum. Not that. I just want to know how was your experience, the good part, and you wanted an area of improvement. Like, oh, I missed that in the courtroom. What did you love the most, Devu? If I got the pronunciation right.
Yes, sir, that is correct. What
Yes.
I love the most would be okay. So when we all go to college, we study audio, ultram, partum, here the other side. But yet, when we hear the first side, we will, because we are all human, we will be biased towards that side. And this proceeding really opened my eye that no, this might not be correct. We have to listen to both parties, even though at the outside it might seem like one party is right.
Okay, okay. Thank
So
you.
I
Thank
could
you.
learn that. Thank you.
You could learn that the practicality along with the academics. Very well. Thank you. Thank you for your experience and sharing your
Thank
experience, Devi. Yes, anybody else would like to add upon some of your practical approach? I don't want any made up story. Okay. If you have really observed, then you say, don't say for sake of it. Yes, who would like to go next?
Yeah, hi sir, Raj. Yes, I haven't really been to a court, but then we watched a lot of proceedings on TV.
Live streaming.
Um, the live streaming, yeah, this Amber Heard and
Oh, the US.
um,
You're following the US jury system. Oh, okay.
yeah.
How about the
Uh,
Indian system?
no, I haven't really been to a court
Okay,
ever.
okay, okay, okay.
But
Thank
then the way they show it on TV, it's very dramatic. But I'm not sure whether it is as dramatic as they show it, make it out to be on TV.
Right, right. Thank you, Raj. Thank you, Raj. Thank you for your experience. Right, the US
Yeah,
system is quite different. Yeah, the approach is different. Dramatic. Yeah, we have seen Johnny Depp and Amber Heard. Yeah, I remember that it
yeah,
came quite often amongst our students also in the past during that time. It doesn't happen that way in India. Okay, so if you're thinking it's going to be the English series of whatever show you want to become Harvey Specter or all those things. See, it doesn't happen that way in India. Okay, the system here is different. So yeah, you got to keep that in mind. Yeah, practical approach is seen. Okay, Shankar says a Tariq pe Tariq and still that case is still in Tariq. Okay, okay. So I think yeah. Again, see, as in the start we got this idea, right? What is the observation and why we need alternative dispute resolution? That you get quite often date. Now, who is accountable for that? As I said, not the judiciary all the time. It's the so, see. There are some parties who are the court birds. We often use the term as court birds. They just file the case, they just create litigation, and they don't appear, they sit over the injunction order, and they don't conduct the trial, right? So Supreme Court has quite often said observe the conduct also of the parties when passing any orders. So I'm going to come back to this phrase again, but yeah, anybody else would like to come back their practical observation? What did they observe? No one.
Hello.
Yes,
Yes, sir.
yes, go.
Yes, sir. So my favorite
Yes,
part
Priya.
about court was basically the drafting experiences. I personally hated the fact that adjournments were taken very often. But then, when the proceedings are going on, it's really fun to watch both the sides say their parts. The drafting is very uh, precisely done as to leave no loopholes for the other party, and that is one thing I really like about all of it. Thank you.
Right. Thank you. Thank you for your experience. Right now, majority of our friends have given their in-person experience, or they observed in the ground reality. Now, I think one thing all of you must be, you can differ from my experience. Like, but quite often, what happens is you see long faces in the court, right? When you all go for dine-in, or when you go for shopping, I'm giving a layman example considering the crowd, right? Now I'm talking about the practicality. So when you talk about practicality, when you go in the courtrooms, quite often in the court premises you find long faces, parties cribbing about the time, the cost, the advocates, judges, the infrastructure. So they have been very critical about it. Quite often you may observe this. I'm not saying all the forums probably go through the similar experience, but that's a majority of the time we have seen that the parties quite often get frustrated in the courtroom because of the reasons we just now have taken up, right? Because see, probably you are waiting for your case to come up. Your case is listed at serial number, let us say 151, hypothetically, right? You are not sure whether your matter will be heard or not. Why you're not sure? Because uh, sometimes the judges are on training, they have gone for a training, or sometimes they are getting a direction from the high courts or the Supreme Court, to pass the time bound orders or the judgment. And likewise, sometimes advocates are on leave. They have taken medical grounds, personal grounds, parties are on leave, and sometimes judges also take leave. So a lot of contributions are there. We have seen the lockdown time during the COVID-19. If all of you would recollect that, that was the only time you will find that I mean, a lot of difficulties the litigants did feel that time, because of the courts were not functioning. Only for limited hours it was functioning, and that came as a blessing in disguise, because nowadays, this is also an online platform through which we are having the discussion. So that was blessing in disguise, and many of the matters got listed, and there were many matters which were argued through online also. So this is what I'm talking about, is the pros and cons of both the court, the judicial system, the court proceedings, and arbitral and the ADR proceedings. For example, we have flexibility in the arbitral proceeding. The timings can differ. We don't follow the typical uh, office hours or the judicial system or the court hours, wherein the timings are there from whatever, 10 to 5 or 11 to 5. So what usually happens in the arbitral proceedings, the parties themselves decide the place, or the timings. You can have it on a weekend, in the evenings. You can have it on the early mornings. That you cannot do in the court proceedings, because court proceedings are fixed. They have a limited time period, and they have got bunch of matters which they have to adjudicate. Right now, these are again the practical aspect which you have to keep in mind. The parties are not happy with the infrastructure, probably. Okay, but at the same time, you have arbitral proceeding that you yourself choose. Okay, I want to have my proceedings in this conference or that particular hotel or resort, whatever you may call it. And sometimes, if there are no ad hoc, now if we are appointed ourselves as an arbitrator, like all of you, you can become an arbitrator, and that will be called as ad hoc. This is called ad hoc arbitration. And if you are panel advocates, like the Singapore Arbitration Center, which is the popular amongst the stakeholders, Singapore, London. In India also, we have Nanipal Keval Arbitration Center, we have ILSCA, we have Mumbai Arbitration Center. So there are a lot of centers which are adjudicating these ADR methodology. They have mediations and arbitrations. So these are called as institutional arbitration centers. Okay, so these institutional arbitration centers are going to give all the facility. So they will have a facility for the refreshment, they will have facility for your administrative purpose, they'll provide you the rooms, they'll provide you the refreshment and all the facility which are required, the desktops, the systems, etc. So again, the difference is there. Now you're talking about the court proceedings, wherein we have judges who have got a lot of matters. They also get frustrated because the advocates are not prepared. So we cannot blame judiciary every time. The advocates are not prepared. They just keep on taking the dates. Parties are unwell. As one of our friends suggested, she observed the chief examination and then cross examination. So you see, it will minimum will take half an hour or 1 hour or so. So when you're going to adjudicate the remaining matters, and that's the reason you get a lot of dates in the court. It's not like we blame the judiciary every time. It's the parties also taking dates, unnecessary delay tactics, and trying to prolong the matter. But if you follow the arbitral proceedings or the ADR, the arbitrator or the tribunal will not allow these adjournments in a routine way. Okay, just remember this. In arbitral proceedings, that is not the scenario. They quite often put cost, which is absolute heavy, and it may also affect the entire arbitral proceedings. Because they understand that you're trying to delay the proceeding, and there's a time period which is prescribed, which they actually follow. Even in the courtrooms, we have the days given for every orders: 30 days, 60 days, 90 days. But for the arbitral proceedings, believe me, with my experience, what I have seen, usually they pass well before 12 months. So when we're going to come back into the legal aspect with a lot of sections and the procedural law and the substantive law, the arbitral proceedings, mandatorily you get the award, which we in the layman language, in the court proceedings we get judgments and decrees, right? So in arbitration we get award, which we call it award, an award which is passed, that is the final adjudication of the proceedings. So the law of the land is that we shall pass the award, we shall get the award within a period of 12 months. This you have to keep it in mind, that 12 months is a time period. To our friends, those who are saying Tariq pe Tariq, it's frustrating or it's a delay thing, that does not happen in arbitral proceedings. Believe me, 12 months you get the award, you get the final award. Yes, if there are difficulties, then with the consent of the parties, they extend another 6 months, then 18 months is a time limit. But beyond 18 months, it's difficult because the law does not permit. Then again, you have to refer the Arbitration and Conciliation Act for that, the time period. Yet another difference between the court proceedings and the arbitral proceedings. And another difference between the court and the arbitral proceedings is also your confidentiality. Many of you know this, but again, I will repeat confidentiality, because the courtrooms are meant for all of us, the individuals, the people. Now this court proceedings happens in an open court. People come, the litigants come, the advocates come. It is open for all. Why it is open for all, by the way? You know that, right? I mean, those who have visited, those who have not gone also. You know that court proceedings are in open, right? What is the logic? Always go behind the logic and the practicality. Anyone? Why we have open courts? I'm not talking about in-camera proceedings or that, but I'm asking you a very basic layman question. Yes,
So maybe to ensure transparency.
absolutely. Correct. Thank you, Priyanshi. Transparency, right? Transparency is one of the reasons. So that the justice is seen to be done. Yes. Yeah, there is no influence. There's no hanky-panky going on. Yeah, it's everything is transparent. Yes. That is the reason it is in the open court. Then why is that open court for trust of litigant? Yes. No, we have a judge also. Okay, nice. We have a sitting judge. Okay, that's nice. Open court for trust of the litigant. Yes, the trust that I'm going to pass the order, I'm going to pass the judgment, and public, the people are there, the parties are there, the court officers are there. Yes, I'm not getting managed. Public education. Fairness, yeah, take the point. Fairness, yes, fairness is the good. Trust on the judiciary system, yes, that is the one, right? But at the same time, if I may ask you for equal and unbiased process, absolutely, this is Sharad, right? Wonderful, it's a great point. No biasness while giving judgment, absolutely, absolutely. Wonderful points. Now, before I come back to arbitral proceedings yet again, right? I'm talking about the court proceedings. Like many of you give absolutely fantastic suggestions and answers to install the trust, and to have faith in the judicial system, unbiasedness, so on and so forth. If that is so, then why is that most of the ADR methods, like mediations and arbitrations, it it glorifies that it's a confidentiality that we love the most. You know that, right? The arbitration does not, you will not find any arbitral award. I'm not talking about court for arbitration of sports, which is a different international body. I'm talking about an award. Majority of the times, you will not find an award, unlike the Supreme Court's judgment or the High Court's ruling, which you can take it up, or which you read from your SCC or the AIRs or the other apps. You don't find awards because they are focusing on confidentiality. Why is that they love confidentiality? Should we allow that, or that also should be happen in the open forum when the people can observe, like the court, isn't it? What are your thoughts? The public at large is not involved in arbitration. Yes, it's a private dispute, na? It's not concerned with public at large. I'm not talking about the international laws. I'm talking not about the nations, I'm talking about the private dispute. Correct? Now, public is not involved there. Here is a private dispute wherein they would love to have privacy. Now, for example, there are two brothers fighting. One brother probably speaks a lot. Other brother does not speak a lot, but he respects the brother. But because of the misunderstandings or the greed or the circumstances, it may so happen that the matter may come back in the court. In the court, now see, there is a pressure. Like few of you did suggest the atmosphere of the court. See, you got to observe the court proceedings. You got to go inside the courtroom, observe the pressure on the litigants, observe the facility, the windows, the files, the court officers, the presiding officers, everybody are performing their role. And here you put your brother inside a witness box, wherein an opposite side counsel will ask questions like our friend Devu and others have suggested, chief examination, cross examination. So they don't want to go through all that. This is one of the example wherein why the parties don't want to go in the court, they want to have ADR. Likewise, the companies. For example, you can take up companies. I gave the example of your softwares and the application. Majority of the companies like Zomato, Uber, Ola, whatsoever you may take it, they don't want to go to the courts. They put the arbitration clause and mediation clause. Why? Because most of the companies are listed. They don't want their name or the goodwill to be sabotaged. They don't want to spoil their name. And if the court proceedings are going on, then probably director or the CEO, CFO, founders, they will come and the public will watch them. They don't want that to happen, because most of the times what happens is because of these proceedings and the dispute, their shares will be getting affected. There is, about the equity markets, right? The shares which are listed in the exchanges. So any outcome of the court proceeding, for example, about Vodafone Idea, probably you would have heard about it. Vodafone Idea, which went to Supreme Court. So the outcome of the decisions by the court will have a direct impact in their profits or the balance sheet, which you may call it. Likewise, these companies want to protect their interest, and they don't want their directors or the board to come in the open public wherein everybody is coming and watching their disputes. No, and that is the reason why confidentiality is appreciated. It will be remaining within the four wall. Yes, they want to challenge, that is a different scenario altogether. But remember, confidentiality is an important element of arbitral proceedings, which is not the case in the courts. In the courts, they will give the order, they can upload the order, we all can read the judgments. Yeah, there are few exceptions. For example, in the matrimonial cases, you may not have the access to the judgments, but for the civil proceedings, yes, on the criminal proceedings, you get the access. Likewise, there could be another advantage. Now, like few of you can again uh, give your thoughts, or all of you actually should contribute to this. How many of you think that court proceedings are expensive? Now, I give you the difference between the court proceedings and arbitral proceedings. I'm on the similar line. How many of you feel that the court proceedings are expensive in terms of cost and finance compared to arbitral proceedings? How many of you say it is expensive? Sharat says expensive. Court proceedings are expensive. Okay. How many of you disagree? No, no, it's not expensive. The arbitral proceedings are expensive. Depend upon the fee of advocate. Right. The okay. Anjali Gupta, thank you. Fees of Acha, by the way, when we go to the court, right? We pay the court fees. The court fees are given as per the state enactments. Like we have Maharashtra court fee, the maximum is 3 lakhs. I'm talking only about civil law, 3 lakhs. And then as per the claim amount you pay, it's not as per the advocate's fee. But your answer is spot on. Yes, towards the end, the litigation cost itself is too much. The advocate's fee, administrative fee, so on and so forth. And likewise, in arbitration also, we have a schedule. You have a statement of claim, statement of defense is filed, then based on the claim amount or counterclaim, if it is there, then you determine the arbitrator's fee as per the schedule. right? There is one more. Arbitration is costlier. Okay. Why? Priyansh. So you are only Priyansh. Yes. Yes. Why you feel that arbitration is costlier?
So seeing to the cases, I would say parties who are like big businesses would go for arbitration, and I think the cost of the same would be higher than the normal court proceedings.
Okay. Okay. Thank you. Anybody else would like to add upon? How many of you? Acha, you're not raising hand or thumb. So I would
Sir,
like
can I say
unmute.
something?
Yes, Dev. Yes, Dev. Same names I'm getting. Yes. Go ahead.
Yes, sir. Sir, we in college, some seniors took a class on arbitration. Okay, so they said while giving introduction to arbitration, they said it is also called rich man's litigation. Arbitration is also called rich man's litigation because it is very expensive than litigation. I was uh, thinking that litigation is actually costly, but then the seniors told that this is not really cheaper. This is also called rich man's litigation.
Okay, so I think I would thank you, Devi, for your point. I think most of you are saying the arbitration proceedings are expensive, right? Will I take that as a point? Arbitral proceedings are expensive, right?
Yes, sir. Yes, sir.
I'm not suggesting that, not me. Okay. So, so yeah, that was the concern. Raj also gives a thumbs up. See, we feel that way that arbitral proceedings are expensive, but believe me, it is not meant for the creamy layer or the big companies. No, we couple of arbitral proceedings which we also did. We see we found out that depends. 1 minute, just depends. Both might come. End of cost. Okay, Dattaji has given the thoughts. Yeah, similar end of the cost. But the see, cost may be similar, not same. But what about the time? Which will give you the fastest remedy? You're comparing cost, but what about time?
Sir,
Which
if
is
we take into consideration the time aspect, then arbitration will be cheaper.
right. So arbitration, you agree? Arbitration is faster. Most of the common answers I'm getting in the chat box, right? So time is money, no? Have you heard about this term? Quite often they say time is money, time is money. Arey, I'll pay you more money. Give me the fastest reservation or blah blah blah. Right. So time is money. So same way the litigants also. It's like the very common phrase they use in a couple of judgments also that your operation is successful, but patient is no more. Operation successful, but patient died. So most of these judgments which you see from the Supreme Court's website or also from the SCC or AIR, you'll find that the parties know they will mention through its legal heirs or LR they mention through its legal heir because they were fighting from 1980s or 1999 or 2000 and the matter ultimately got decided in 2025. You see, by the time the actual purchaser or the owner is no more, so that person is no more to enjoy the benefits of the litigation. So, time, what I'm trying to focus upon is also time. In the arbitral proceedings, it is fastest. It is it compared to the court proceeding, it is fastest mode of getting the award, the final outcome. And remember one thing: when I gave you the hierarchy of the courts, now you got to understand that senior division, junior division, senior division, district court, high court, and supreme court. This is the hierarchy, right? So when if you are unhappy with something, an order or a judgment or a decree, any outcome, layman understanding, if you're unhappy with the outcome of the court proceeding, right? You cannot put allegations against a judge. You cannot put the allegations, or you put a flaw. Arey, nahi, the other side advocate was not that good. My arguments were better, or some they did not understand the law. You don't make such remarks. Not advisable, and don't make any suggestion of those kind. The law is very clear. Supreme Court has time and again said, if you are not happy, then find out the provisions which are given in the act. So you get appeals. If you're unhappy, check the provision for appeal. Are there any provisions for appeal? Just like how we have sports, right? Now, again, I give the layman example for everyone so that they understand the law. you follow cricket or tennis or any other sport, there is something called review. You remember that? In cricket, we have DRS, review system. No, or if you tennis, if you watch, there also you have this Hawkeye and all that, that review. So in the court proceedings also, we have these the methods. If you are unhappy with the order or a judgment or a decree, then you can go to the uh, superior courts as per the law. If appeals are there, go for appeal. Appeal is not there, check for review, revision. That is also not there. Then only you file writ petition. By the way, everything is not writ petition. Writ petitions are not the modes which probably sometimes we see in the moods. Everything is writ petition, writ petition. No. If there is no other remedy available, only then you can knock up the door of the extraordinary remedies of writ petition. So this methodology, this hierarchy from junior division, senior division to district court, then high court and supreme court, it will take a lot of time. And in the court proceedings, when I talk about appeal, the first appeal is our right. Just remember this. Most of the time, first appeal is our right, and the more higher we go, then you have to talk about substantial question of law. In arbitral proceedings, they will not follow the similar methodology. So when you're going to read section 30, now I'm talking about arbitration act. Let me also add the legal aspect. Now there is the arbitration and conciliation act. I'll give you the details now and elaborate more about it. But there is a specific section which talks about how to set aside that final outcome, which is called as award, setting aside of arbitral award. How to set aside and what are the grounds for that. So unlike the court proceedings, imagine now I can see only two faces in front of me. Shubham is there and Priyanshi are there. So I'll take their names. Like they're representing their respective clients. For example, Priyanshi is representing hypothetically Tata Motors. Okay. Shubham is representing, let us say, Tesla. Hypothetically, not promoting, not defaming, just to understand. They had this joint venture, there's a dispute, and then the joint venture agreement has an arbitration clause. Okay, both the parties agree, okay, we'll resolve the dispute before an arbitrator. And let us say Devu, because she was saying apart from others, Devu is an arbitrator. She passes the award in favor of, let us say, Shubham. Hypothetically, I'm not taking anybody's side, just to understand the problem. So Tesla wins the case, and award is passed by an arbitrator. Who? Devu. Now, Priyanshi's clients, Tata company, the Tata Group, Tata Motors, they say we want to appeal, we want to challenge, or we want to go in the higher courts and challenge the outcome of the award, the arbitral proceeding, right? In arbitral proceedings, there are grounds mentioned that on what grounds you can challenge the award. Unlike the court proceedings, wherein the first appeal is your right. Just few minutes back, I told you, if you're unhappy with the order or a judgment, then you can file an appeal against that. In arbitral proceedings, we have provisions for appeal also under 37. But to set aside the arbitral award, which is the final outcome, only on the grounds which are mentioned in 34, section 34, only on those grounds you can challenge and nothing else. That's why it is different. That's why it is different from the court proceeding. For example, the outcome has come, okay, that Tesla will get, let us say, 50 CR from Tata Motors, right? Now, Tata Motors wants to challenge that. Now, only if those grounds are satisfied, you can challenge that order, award, which we call it in the arbitral proceedings. And this will be adjudicated faster. Like you got the award, first of all, within 12 months as per the law, or let us say 18 months. And then Tata Motors is challenging it. It will take another 1 year or so, or 2 years or so. And then they challenge it ultimately in the High Court or Supreme Court. So within maximum 3 to 5 years, you'll get the outcome. And compare this with the court proceeding. Because just now I said a few minutes ago that in the court proceedings, you have procedural law, the Code of Civil Procedure. So it will talk to you about who can be a party to a suit, who will be the parties. Then you will check a lot of orders. Order 1 is there. How to serve the summons. Summons are like the intimation from the court. Okay, how to give the summons to the other side. Few minutes, few hours, I mean 1 hour ago, somebody said about audi alteram partem, right? Here the other side. So that's why you get notices from the court or the summons, which we call it. How to serve the summons, follow the procedural law. And I quite often call that as a very frustrating stage. Why? Because to serve the summons, it will take a lot of time. Parties are not found, the bailiff is gone there. No, I'm not putting the allegation or something, I'm just giving the practicality, the difficulty which the parties feel. The summons are served, the door is locked, intimation is delivered, the court bailiff has come back. Yeah, I was there, but I could not find here, her or him. I came back, or the address is incomplete, so on and so forth. Sometimes the defendant is there. Now, this is the practicality. Sometimes defendant is there at home only, but he's saying the bailiff or some other person, "Arey Baba, you tell them, just make a report. I'm not there." Now, again, I'm just giving you the practical difficulty that you get this difficulty wherein the parties are not found. Then what we do? Then you again make an application to reissue the summons. Again, get the party. Then they'll file the written statement, so on and so forth. This cycle will take minimum 3 to 5 years. This is how the time period is going to be. So here you have three years, 5 years in the very first forum, the first court, civil judge, senior divisioner, and then district court. You go for an appeal, then second appeal in the high court, and then SLP in the Supreme Court. Minimum 10 years to 15 years, roughly. And you're comparing this with arbitral proceedings, wherein you're talking about getting the final outcome itself in 18 months, 12 months actually. And then the awards which are going to be challenged under Section 34 are limited, very limited in scope. Right? So this is the first aspect which I want to discuss. Yes, we should have a break or something in between. You tell me, because I can continue. If anybody, yes, the MC or the student in charge, they can tell me with the rules and regulations of the.
No, sir, no as such breaks are needed right now.
Okay, very well. Right. So again, now come back to the law. Now, this arbitration, which we are here for, the arbitration law, this is actually not of 1940, the original act, or 1996, the principal act, or the amendment of 2015. This arbitration or alternative dispute resolution, as the shloka was read out in the beginning, right? It is there from that time. The epics, the Ramayanas and Mahabharat. That time also, when there was a dispute, remember? The law was there, by the way, you know that, right? Dharma, law was there. You can see, you can observe the law that time also. When you read Ramayana or when you watch Ramayana or Mahabharata, what laws you find there? That somebody has taken, kidnapped, or something you may call it, against the will, against her wish or the will, and then Hanumanji is going there with the peace talk, is trying to resolve the dispute. Same thing, similar thing happened in Mahabharata also, right? Like you were fighting for a piece of land. Actually, that only. Now you were fighting for partition or the land, and then Krishna went there again as a mediator, as an arbitrator. Okay, let go. You keep half. So arbitration is nothing new. This was there in the past also. Now we have got in the enactment in the present decades, we may call it. Otherwise, Mahabharata, Ramayana, and other empires also have these in the past also during the kingdoms. That time kings were there. They also used to pass the judgment, right? Like the judges. Okay, we have been caught. Okay, what he has done. Okay, and then to take advice from what you call mantris and all that, right? So this system was there in the past. So the history I'm basically talking about, the evolution of the arbitration and mediation. It's not of the recent one. It was there in the past. Now we have got better version of it. As I told you, in Mahabharata, even in Ramayanas, you find the elements of the law. How to fight war after that sunset, no war will take place. So you see the elements of international law. I mean, I don't know whether you know about public international law also. So there are lot of, yeah, Rishabh has given thumbs up. So there are a lot of elements of law involved. So likewise, Manusmriti text is an example of ancient legal system. Right? Yes. Thank you. That is the point. So in arbitration also try to understand that as we discuss that who can be an arbitrator, person of any quality, any person can be an arbitrator. For example, if I pose up a question now our friend has come. I forgot the name is not displayed there. So our friend
I'm Rohit, sir. I'm Rohit.
Rohit. Rohit.
Rohit.
Okay,
Yeah.
Rohit. Now, let us say Rohit says, now imagine I am from Pakistan, hypothetically again, okay? Now I'm from Pakistan. Rohit says, in this dispute between, again, Tesla and Tata Motors, our friends who are there, Priyanshi and Shubham as the counsel, right? Says they want to appoint me as an arbitrator, but I'm a Pakistani. Can I become an arbitrator? Pakistani, again,
So
war,
I don't think so.
competition.
Maybe the Tata is from India. It may be a biasness in the matter.
Thank you. Thank you, Shubham. How many if we say no, just give thumbs up. Okay. How many if we say yes? Just put that. Acha, if you are unable to, you can use the chat box if you are, I don't know, if you can use the chat box. Yes, you have chat box. Yeah.
Yes.
Yeah.
Yes, if your credentials and if it is, if, acha, I want to know this. This is interesting. If it's in the London or Singapore bench, why? Why not India? Shankar. Yes, can you unmute yourself, please? So I want interactive one. I don't want legal jargons to be used. This is practical approach. Yes, Shankar is there. Am I audible?
Yes, Shankar, you can unmute yourself.
My
Okay.
mic is bad. You're not afraid or something. No, don't be fearful. Okay. These common pointers. Okay, okay. Your mic is bad. Yes. Anybody would like to suggest that? Anybody else?
So, considering the geopolitical situation in Pakistan and India, and then we are at war with them, and
Currently, yes.
that
Currently, I understand that. But
yeah,
generally,
that would be the reason.
generally,
Yeah, yeah, we can appoint them as
yes.
arbitrators. Yeah,
Okay.
for sure. There's no reason that they cannot be appointed as
Thanks, Raj.
arbitrators.
But there is a suggestion. Thank you, Raj. But there is a suggestion by Shankar that in India we see Pakistani as an enemy state. Now, see, I don't want to get involved in the political talks and all that. Not the warlike situation. I'm just talking about. We're just learning about arbitration law. And under arbitration, you got to have this clarity that person of any nationality can be an arbitrator.
Exactly.
Just
Yes.
remember this. I am not saying these are not made by me. This is given by the legislature. You'll see under section 10 when we'll attach that enactment also. So little bit of technicality of the laws. Under section 10, there is a provision. There is a section which talks about number of arbitrators. And then you'll find that provision in subsection that person of any nationality can be an arbitrator. Person of any nationality can be an arbitrator. But provided the number should be an odd one, not an even number. For the arbitral proceedings, there will not be any even number. So you'll have one arbitrator, which is called a sole arbitrator. Sole arbitrator, three arbitrators, five arbitrators, so on and so forth. Right? Unlike the judicial system, you have one judge in the trial court, a single bench in the honorable high courts, and sometimes you have a division bench. Two benches, two judges sitting together, and then you have a constitutional bench, right? So why we want odd number? Because we don't want any even outcome. Like we are four of us, like all of us are there, but on the screen there are only four. I mean, I can see faces, right? Like if we have to have a outcome right now as an arbitrator, four of us, we should have that split of majority. But if we have two and two, there will be a tie. That's why the legislation has mentioned in the act itself, in the scheme, the entire section, the parts are divided. There you'll find that person of any nationality can be an arbitrator, but provided the number should be odd. This is another thing which you have to keep in mind. And likewise, when you're talking about more about arbitration law, therein you will find that if you are a judge, now you got to keep that in mind. If Tesla, no example which we have linked the example, Tata Motors and Tesla, our friend Priyanshi and Shubham, they are the counsels for the respective parties. Now they're representing the parties in the proceedings. This we got clarity. But for example, Shubham, he's the counsel for Tesla. He does not go to the arbitral proceedings. He does not go to Rohit. Imagine Rohit is the arbitrator, the named arbitrator. He does not go there, but he files a case against Tata Motors in the court. And I want recovery of money, I want specific performance, whatever it may be. Now, as a sitting judge, it is your duty, first of all, to identify whether there is an agreement or contract and whether that contract and agreement has an arbitration clause or not. If there is an arbitration clause, the parties cannot bypass. That's the reason why I told you. If you have a dispute with Zomato, now I'm taking Zomato quite often. Let me take Interglobe Aviation. Let me take Indigo Airline, right? Now you're taking from flight from one place to another, and let us say from Delhi to Pune, right? Now you book the ticket from Pune. You are a permanent resident of Pune. Do you travel from Delhi to Pune? You are unhappy with the performance, and assume Indigo's registered office and the operation, the corporate office, everything is in Delhi. And in the terms and conditions, they have mentioned, in the terms and conditions, they have mentioned that any dispute will happen, the exclusive jurisdiction lies with the Delhi courts, the courts at Delhi. Now, in this regard, where you can file a case? Now, that's why I told you in the start, you got to have a clarity of the three thoughts: the court, the forum, the parties, and relief. Now, here is an agreement wherein you agreed on the terms and conditions on their web check-in and the online booking which we all do, terms and conditions. And they have somewhere in T and C they have mentioned all disputes arising out of this shall be resolved before courts at Delhi only. Now, can you file a case in Pune? I'm changing the illustration, by the way. All of you pay attention. I'm giving you multiple illustrations, very basic ones, so that all of us can follow the same. Anybody can jump in. Imagine you are representing the person traveling from Delhi to Pune. You're like, "Arey, kya service hai? No, cannot file case in Pune." Sharat says, "Okay."
No, sir, we can't. It is explicitly mentioned.
Raj says, "Okay, we cannot." Okay, thank you, Sharad and Raj. Yes, we cannot file a case in Pune. No, cannot file. Okay, got it. Anybody
You
says
probably
yes?
can, but the proceedings would take place in Delhi.
Delhi. Okay. No, that's why you should have. Thank you for the suggestions. Have a clarity. White or black. Don't have a grayish. Okay. Now the answer is you can file it in Pune also. No. Now again, court parties relief, the forum parties relief. What are you? You are an individual who took the service of. Again, I'm just giving an example of Indigo. They're the best airline. I just traveled again. Good airline. Just giving an example. You're unhappy with the service. So you find it in Pune. Can you find it? The answer is yes. You should ask me why in Pune, though the agreement and the clause said in Delhi, because again you're choosing the subject matter, you're choosing the jurisdiction. So if you are a consumer, you can file wherever you are, no? Yes or no? If you're a consumer, you'll file the case wherever you are sitting. You will not go all the way from Pune to Delhi to fight the case and come back. In this example, not each and every example. Now, with this background, this mindset, come back to our main example, wherein Shubham is representing Tesla, Priyanshi is representing Tata Motors. They have an agreement which is called joint venture agreement. Layman understanding is they want to work together, collaboration for their entities. Like you have seen what is that? Starbucks, it's a collaboration between the two bodies. Likewise, they have entered into this agreement and they have agreed that any dispute will arise, they will go before an arbitrator, our friend Rohit. Right? But Shubham did not go for arbitral proceedings. He filed a case only against Tata Motors in the court. In that regard, what will you do as a judge? First of all, identify whether there is an agreement or contract. Okay. And then identify what kind of dispute it is. Now, this is important. This is what Vidya Jolia's judgment and many judgments of the Supreme Court has said, whether the dispute can be arbitrable or not. The word is arbitrable. Now you cannot send a dispute for arbitration whether when there is an offense against let me offense against body, murder. You cannot send for arbitration. Matrimonial dispute, you cannot send for arbitration. You can mediate it. You can have a counseling session in the family court, that is there. But you got to understand the arbitrability. So whether the dispute can be arbitrable or not. This is the second element you have to keep in mind. But remember, the law is clear. You will read section 8 somewhere. As a judge, judicial authority before whom, a matter has been brought up, suit has been filed for recovery of 50 CR or 10 lakhs or whatsoever. And then if the judge finds, or the opponent, if Priyanshi says, okay, no, but there is an arbitration clause. There is an arbitration clause. So this matter should not be adjudicated by this judge, and this honorable court shall refer the matter to tribunal. This can be done as per the scheme of the act. You getting it? So if the parties are trying to bypass the agreements and the terms like this, unlike the first example of Indigo, I'm talking about the second example now of Tata Motors and Tesla. So here there is a specific arbitration clause. So the parties have to compulsorily resolve the dispute before the tribunal, the arbitral proceedings. They cannot come to court. Any question till here, anybody? I'm going a little technical now because it is required as per the, I think the syllabus which was shared. I'm going to discuss more. But till here, anybody has any query? From 42, it become 38. Okay.
So it is raining in Pune, so there is network error as well. So
Okay.
many are complaining about it.
Right. But any question till here? See, you ask me practical questions, academic questions, or any question regarding the subject matter. So it'll become more interactive and easy. And see, sooner or later, you all gonna use this, whether you want to be in this legal profession or not. But at least you can thrive to become an arbitrator or a mediator. Now we have got a mediation act also. Mediation. Right. Now though now
So yeah, I have a question, sir.
yes, please. Raj,
Just
yes, go ahead.
if I buy a product from a Mumbai store and then the receipt says that um, the jurisdiction is Mumbai, any dispute that arises, then can I file? I'm not sure whether I can file the case in Pune. Also, then what's the point of having that clause in place in the first place?
Thank you, Raj, for your question. Excellent question again. Just let me know whether I got your question correctly. The question is, a service or a product has been taken, or order has been placed from Mumbai, which has been delivered, right, to Pune. But the receipt or the bill said the disputes will be settled at Mumbai only, right? Raj, got it right? Right.
Yes, sir.
Right. The suggestion is, in the situation like this, uh, if we can file a case in Pune, then why to mention that clause at the very first place? This is probably going on in majority of your mind, right? If I'm saying that, okay, even though you mentioned that, but still you can file a case in Pune, then what's the point of having that clause? It's just like I give an example yet again. In your dispute between Tesla and Tata Motors, you mention any dispute arising out of this joint venture, or all the disputes arising out of this joint venture shall be resolved by the Supreme Court of India, New Delhi. Now, is it valid? Think about it.
Yes,
Then, yes, Raj. Yes.
yes, I think so, because if both parties are in consonance with this this term, then it should be valid.
Right. Okay. Thank you, Raj. I'll come back to you. Anybody else who concurs or who agrees with our friend Raj? Yes, if it is mentioned, then Supreme Court of India, na? Then there is no cost, there is no waste of time from
Not Supreme Court per se, but maybe the court that they agree upon.
Supreme Court of India,
Um, I'm not sure whether we can approach the Supreme Court directly,
High
or
Court,
anyone can.
Bombay High Court directly. Now,
Then the hierarchy is bypassed, right? The
exactly. You got it right. Exactly. So parties, thank you, Raj. So he himself asked the question. He gave the fantastic answer. We cannot carve out the law like this. We cannot carve out the law. Okay, tailor fit for our understanding. They directly will go to Supreme Court. Directly, we will try to bypass the procedure. That is not permissible. Though under the arbitration law, we have the liberty to appoint an arbitrator, but in the judicial system, we cannot do that. You got to understand this. When you're talking about judicial system, there's a hierarchy which I gave you a few minutes ago, if all of you will recollect that. So you cannot carve out the law just like that. For example, I make an agreement to assassinate the individual, and you take the money, and then you don't assassinate. I say, okay, return my money. Now we agreed, no agreement. So the law of contract is there in daily life.
not
Lawful
law.
offer, lawful acceptance, lawful consideration, meeting of the mind, again, quid pro quo, all those things. So similarly here, we cannot carve out the law like that. To your question, Raj, you had placed that. I think you got the answer. Like you can file it here because again, you're choosing the law. If you're a consumer, not a service provider, you're a consumer, you have consumed the goods or you have taken the service, and you talk about unfair trade practice or deficiency in service, you can find the case here. There shouldn't be a problem. You will not go all the way to Delhi to file your case against Indigo. You all follow, you are getting the hang of it, right?
Yes, sir. Yes.
Right. So you have the hierarchy in one place. So that's why there is a term called jurisdiction. Jurisdiction. I told you again, the court, the forum, the parties, relief. So you should know which is that forum will I go to, what that forum will give me, whether this forum is competent to give me the relief. So the forum is important, the court, the parties, relief. Now, courts are multiple. As I told you, these are the basic hierarchy of the courts. But likewise, you have various tribunals for the debt recovery. If you take loan from the banks or NBFCs, so you have debt recovery tribunal. That is the subject matter. You have to focus on the subject matter. When I spoke about arbitrability, dispute, arbitrability. Check the dispute. Partnership dispute. Can you refer before an arbitrator? Answer is yes. Matrimonial dispute. Can you refer before an arbitrator? The answer is no. You have a family code for that. Okay, offense against body, murder, so on and so forth. Can you refer for an arbitration? No. It's an offense against a state or an individual. For that, you have BNSS and BNS and BSA, earlier which was CRPC and IPC. So you got to understand the jurisdiction also. And that is the reason why, now coming back to arbitration yet again, in arbitration, quite often what used to happen earlier, the parties used to plead this fraud. कि भैया Tata Motors have done fraud against me, so we cannot refer this matter before our sole arbitrator, respected Rohit ji. We cannot refer this matter because there is a fraud now. Fraud हो गया तो criminal offense. So now that element is gone. Now Supreme Court changed the stand. So earlier what used to happen, no, I'm gonna share those judgments of the Supreme Court. There was a famous judgment of N. Radhakrishnan versus Mastro Engineering. N. Radhakrishnan versus Master Engineering, partners, friends coming together, dispute happen. He found out that the two of my friends only are trying to siphoning the money and all that. So he says, okay, I want to resign it. You all continue. Give me my share. And then, similar thing came up before the court. And then it was like, no, no, there is an arbitration clause. So please refer this matter to the arbitral proceedings. Then the opposite side advocate argued, ki, no, no, you only saying fraud, na? If fraud is there, then arbitrator cannot adjudicate this dispute. Arbitrability. So, no arbitration. So everybody started using this precedent of the Supreme Court. Oh, there is a fraud, then we can bypass the arbitration. Then later on, after Swiss and Swami's judgment and all that, Supreme Court changed its stand. They said, no, no, what is happening here is under the, this garb of fraud, everybody is trying to bypass the arbitral clause itself. So that's why you got to focus on arbitrability also, whether the dispute can be arbitrable or not. And remember the thumb rule for the arbitration proceeding and even the mediation, that it is the civil dispute which you can arbitrate in ADR methods, not a criminal matters. Likewise, in arbitration also, you have the court's definition given. Which court? When I'm talking about court, so you will read under section 21E. Court means what? The original side. And then for the international commercial arbitration, domestic arbitration, which forum is there? But remember this forever in your life. Under the arbitral proceedings, you have the power of the parties. It is the parties who decide what will be the language. Language also they decide. Unlike the courts. Now, this is another difference between the court proceedings and the arbitral proceedings. Apart from the high courts or the Supreme Court, you have regional language in the trial courts. Many of you may not know Punjabi. So if I tell you, okay, Priyanshi, start arguing in Punjabi. I'm not sure. You know the language or not. Or I'll tell Shubham, okay, you argue in Malayalam. So it's difficult, no? But if you're in the court, you cannot say, no, no, I don't know Malayalam, I don't know Punjabi, I don't know Marathi. You got to learn the language because the regional courts, the trial courts, we follow the local language. It is convenient for public, not for the you and me, not for the advocates. And that is the reason why the High Courts and Supreme Court, again, it is by the mother, the Constitution. There you have English as a language, and there is a nexus also why English, because tomorrow if you're appointed as a, let us say Rohit becomes the judge of High Court. Rohit, you are from which part of our beautiful country? Which city or state?
Pune,
Pune.
Maharashtra.
Pune, Maharashtra. So obviously you will know Marathi, Hindi,
Oh,
English.
येतं.
Very
One
nice.
language.
Now if I transfer to Punjab
Hmm.
and I'll ask you to chalo pass the judgment in Punjabi,
Not possible.
not possible, no?
Yeah.
So as a trial court judge, it is not possible. So that is why majority of the times you find that in the high court, the language is in English. So we don't want any political debates and all that, right? It's about the convenience of the judges also there. You have a high court judges who are gonna pass a constitutional judgment probably. And if you get he gets transferred from Pune to let us say uh, Amritsar, and then chalo bhai, you pass the judgment in a trial court. I'm not talking about high court. High court will be more than comfortable in English. And likewise, Shubham, where are you from? Pune?
Sir, Patna.
Patna. वो हुजूर बोलते हैं ना वो लाइव स्ट्रीमिंग में हुजूर.
Yes, yes, sir.
If I send you to Karnataka as a judge, you're a sitting judge, let us say, of Patna Civil Court, and then you get transfer to Karnataka. चलो कन्नड़ा में जजमेंट लिखोगे. You may learn the language, difficult, no? So that's why in the high courts you have this language. Why I'm talking about this? Because in arbitral proceedings also, no, you have this freedom to decide language. So as I say, see the freedom, the basic crux of this differentiation between the court proceedings and the arbitral proceeding is the flexibility. You choose the judge, which is called as an arbitrator of your choice. You choose it. You also choose the language. You also choose the language, Hindi, English, Marathi. Now see, international players, they may not know English every time. Japanese, they may not know. South Korean, they may not know. So you have this issue of language. So language can be decided by the parties in the arbitral proceedings. Language, number, venue, where to meet. Now, if the dispute is happening in Pune, a dispute regarding a land, so which court you will file the case? Now, this is called the territorial jurisdiction, the Pune, at Pune. But if you have an arbitration clause or the arbitration agreement, even though the dispute is about the land, you can still go in Singapore and decide about the case, or in Patna or in Delhi. You can sit, the parties can decide. That's called the place of arbitration. And that's why, time and again, we have got this. In the past, we used to get confused. What is place? What is venue? What is seat? These words are quite often used in a lot of judgments and a lot of moods. I mean, when we judged also, lot of time you get this problem: seat, venue, place. Now, I always give this example when I take the ADR lecture, also in the past and recently, that it's very easy to remember. So when you go to college, let us say you all go to the college, right? So that is what? It's a permanent place, no? For your entire 3 years or 5 years course. Correct? So that is seat. And what is venue? Venue is a division which keeps on changing after every semester or a year. You're on the third floor, you're on the second floor. That is venue. You all are getting it. If you don't understand this, for example, I'll make it very layman. When you go out amongst your friends, right? So let us you work at the same company or a same organization. So that is your seat. You all are working for ABC law firm. Let us assume that, right? Now you say कि आज खाने पे कहाँ जाना है. So you're changing the place, not the place, what you call the venue where you want to eat the food. So that is venue. So remember this: seat, place is permanent. Seat and place is one term only. It is permanent, and venue is the one which keeps on changing, flexible. जैसे आप क्लासरूम में जाते हो, आपकी एक परमानेंट क्लास है, बट कभी आप आगे बैठते हो, समटाइम you sit behind. What is that? Venue. Convenience. You can you narrate, all of you? No, I don't see all the screens on, so I cannot read your faces.
No, yes, sir. You've been very lucid and articulate. So yeah, we're
You can
following you,
follow
sir.
that. Right. Thank you.
Yeah.
So I hope all of you.
And thank you for being so articulate and getting into the weeds of everything.
Yeah. So I'm glad you have. Otherwise, what's the point of having this? So feel free to ask any doubt. Academic, practical, all doubts are innocent.
And, yeah,
Yes.
you've been lucid and very articulate and very eloquent all along.
Excellent. So I'm glad that all of you are following it. I'm going with that presumption. So venue and place and seat, you got to identify that. But remember, in the act, the Arbitration and Conciliation Act, you find the word place, place of arbitration. They don't use seat, they don't use venue, but they write place of arbitration. Right? Now, again, another important thing which you have to keep in mind is, in the entire arbitral proceedings, right from your day one till you give the outcome, that is called an award. If anybody who did not understand this, now is the time to pay attention, because I'm making up in a very interesting way which you can follow. Now, the job of an arbitrator is just like a pilot. Now, I used to give this example before, unfortunately, that May incident, but I often used to give this example. The arbitrator's job is to ensure that he's taking that flight. Now, he's taking that flight from one place to another. His role is to ensure he will take up that dispute and he'll pass the award. That is the destination, origin and destination. Can you connect it? There's no chart option over here, but remember this: here is the origin and here is destination. So the arbitrator's role as unbiased and neutral person, this you have to remain from the origin till destination. Okay, you getting it? From the start till the end, you have to remain neutral. You have to remain unbiased and you have to treat the parties equally. Because in the scheme of the act, in Arbitration and Conciliation Act, it is mentioned that you have to give fair treatments of the parties. Now, parties themselves appoint you. They appoint an arbitrator. They decide the procedure. If they fail to decide, then the arbitrator will decide. Place also they decide. If they fail to mention the place also, then the arbitrator will decide. So the lot of responsibility and accountability is given to the arbitrator. But try to understand that not many parties would like to appreciate defeat, right? It's very difficult to accept defeat. And here is another case where an award is passed against you, and then you try to challenge it. So, as an arbitrator, just remember that award is like your baby. Now, I'm giving this basic example so that you can able to recollect. That award, the final judgment or award which you're giving, we call it award in arbitral proceeding. Treat it as like a baby. Like tomorrow, somebody will take this baby in the district courts or the high court or supreme court to challenge it. No, no, the arbitrator did not follow this law. This was not followed. I was not giving a fair opportunity to present the case. It is against public policy, corruptions, and all those grounds. Only on those strict grounds they have to prove. So, unlike the court proceedings, if you want to challenge the arbitral award, it's a very difficult task under Section 34. That is the reason why I said, as an arbitrator, remember, pass an award with this mindset that tomorrow one of the parties may challenge this in the future. But your job, what is your job? Your job is to ensure from day one till last day, you are still neutral. You are giving fair treatment. Don't become biased. For example, during the proceedings, now Rohit is not there. Now Rohit gets shares of Tesla. Rohit gets 100 shares of Tesla. Very expensive. It's not in India, but he gets 100 shares of Tesla. Now, Tesla and Tata Motors are fighting, by the way. So, before the appointment, also, remember this, you have to give disclosures. Because though parties are appointing, unlike the court proceeding where the judges appoint themselves or they have a constitutional provision how to get the appointment done, in arbitral proceedings, Shubham's client Tesla and Priyanshi's client Tata Motors, they agreed to appoint Rohit. Now it is a duty of our friend Rohit as an arbitrator to ensure that he will give disclosure that what is the conflict of interest. Okay, I'm becoming an arbitrator. I'm obliged that you're making me as an arbitrator, but it is my duty to ensure I'm giving you this, the glances that there may be a conflict of interest. Like tomorrow, if Tesla wins, then Priyanshi's client would say that, just a sec. Yeah, so okay, I'm just running short of time, I guess. Yeah. Okay. So to sum it up, what I was just trying to tell you is you have to ensure that you're unbiased from day one till day last. And then also ensure that if there is any conflict of interest, you disclose it as soon as possible. And in the beginning, you do disclose this. And that's why you have scheduled in the Arbitration and Conciliation Act, which we're going to do it tomorrow. You have schedule 4, 5, 6, 7, which talks about fee, disclosures, how many ongoing arbitral proceedings right now, what is your experience, what is your qualification. So, see, they are not having a prerequisite that you should be an advocate to become an arbitrator. No. I'm an engineer, I'm an artist. So, we had an arbitral proceeding in the past wherein, without taking the name, the person was an artist. We had a doctor who was an arbitrator. We had an engineer because it's an engineering dispute. So the point is again, just like I give the example of flight. That's why I give the example of flight. As a pilot, your job is to reach from origin to destination, right? In between, you will get turbulences. Conflict of interest is like a turbulence. You will get rain. Visibility is less. So those are the obstacles. The party will say, no, no, you're favoring that. I don't want you anymore. So these are the things which you're going to come back tomorrow and analyze it. Okay. So I'll take up few questions right now. I think last 2 minutes are only there. So if you have any query, you may please feel free to ask. Today was the introductory part, keeping in mind the schedule and the syllabus which has been shared. I'll try to cover everything. And once I come back tomorrow, I will also try to share the judgments with you. But yeah, I would like to take some questions if all of you have it. Any query, suggestions, please feel free to ask.
The students, you can unmute yourself and ask questions.
No compulsion, okay? Don't ask
No,
for sake of it. If you have, please
everybody.
ask. I'll be more than happy. And if somebody is shy or reluctant, you can drop a mail or you can put in the chat box. See, everybody is unique. You got to respect that.
We have one question, sir.
Yes. So
So,
when when an arbitrator is appointed, will there be any contract between the parties and arbitrator? Okay, good question. Now, see, thank you for your question. Now, their appointment itself is done by the parties. So, arbitrator don't have any agreement or a contract with the parties. It is the parties who have agreed to appoint them. For example, Priyanshi and Shubham's client, their parties have decided that they will appoint Rohit as an arbitrator. So, the arbitrator does not have any contract with the. He's not an employee, so he's an independent person. You got to keep that in mind. I hope I clarified your query.
Hello.
Yes, Raj. Yes, please go ahead.
Yeah, hi, hello, sir. So you made a brief allusion that it is a time bound and it can be actually more budget friendly. But then why there's this general perception about the arbitration that it is reserved for big corporations, and despite you making a very compelling argument that it is the other way around.
Right. Thank you, Raj, for your question and the practical question. If that is so beautiful, if I'm speaking so beautifully about and promoting ADR and arbitration, then why is that there cannot be a smoke without fire, right? So is our friend is suggesting, then why is that they are saying it is meant for the corporates and the bigger clients? See, it's partially right, because quite often what we see, who are the arbitrators? Probably a retired Supreme Court judge or retired High Court judge or a district court judge or a practicing advocate. So if that is so, it's going to be on the higher side. It is expensive. Or if you want institutional arbitration centers like SIAC, London, or ILSCA, or NPAC. So all these arbitral institutions have got its own rules and regulations. So the Schedule 4 will not be applicable to them. Raj, I hope others are also following it. No, it's changing, it's evolving. Like people like you all of us can become an arbitrator even. I'm an arbitrator myself. You all can become an arbitrator even today. You go home, don't make up a dispute. If there is a dispute, then you say, okay, I'll try to resolve. You can observe, you can do it. See, again, it was not a recent origin. Sarpanch used to be there in the past. You remember Sarpanch? Do they wish to check, okay, what are your qualification? No, it's the experience, it's the quality. Like you said about Johnny Depp and Amber Heard, jury system. So what they check,
Yeah.
credentials, respectable person. So see, it's expensive as of now sometimes, because there are arbitrators who are actually very occupied. They're extremely occupied, and you have retired Supreme Court judges and the High Court judges also. So that may be the reason that it becomes expensive, or the institutional arbitration center also becomes expensive. But there is a advantage now. This question in like another suggestion I would like to give. When you go in the court, the one who is approaching the court pays the court fee. Remember this. But in arbitral
Yes.
proceedings, both the parties pay half and half. Okay. So that's an advantage. Like in the court proceedings, the one who's approaching the court, plaintiff or the applicant or the petitioner, he or she or it pays the court fees. That's not the case in arbitration. In arbitration, both the parties pays equally. If the arbitration fee is 10 lakhs, so Shubham's client will pay 5 lakhs and Priyanshi's clients will pay 5 lakhs. That's another point which I would like to discuss tomorrow once we are back. Raj, I hope I can give a clarification on that.
Absolutely, very lucid, sir. Yeah, very cogent.
Yes. Okay, thank you.
So
Yes.
I don't think so. There are any more questions, sir.
Okay.
Sir,
Excellent.
thank you very much for
Yes, I
such
hope
a mind-storming session. Now I would like all the participants to just switch on your cameras for a group photo. Is all the participants
also, is it? I would be love to seeing each and every one of you during the lecture also.
Okay, tomorrow, sir, we'll try.
Just possible. See,
Request
if it is
everyone to be
anybody is
participating.
uncomfortable, don't do it. I mean, if you are practical difficulty, don't do it. I
Yeah.
mean, I can read the faces. I can try to understand that.
Yes, sir. That's. Thank you, everyone. So I would like Priyanshi to please proceed with the formal vote of thanks.
Thank you, sir. So I'll just begin with a short slok to sum up what we are here for today. Uh, Satya bruyat priyam bruyat dharma marge vichadara न्याय संघर्ष विजिस्त्यात् प्रजा विवर्धन सबका कल्याण बढ़ाते हैं आर्बिट्रेशन केवल विवाद निपटाने के लिए नहीं बल्कि सत्य और धर्म के आधार पर एक समाधान देने के लिए है जो दोनों पक्षों के लिए न्याय और समाज के लिए कल्याणकारी हो As we conclude today's enriching discussion on Vijay Path, from claim to victory, I bow in gratitude. Today, we witnessed how arbitration reflects this eternal principle. True victory is not about conquest, but about dharma, fairness, balance, and truth. A claim, when resolved through just and peaceful means, becomes a collective triumph not of one party, but of justice itself. I extend my heartfelt thanks to our respected Dean and Principal, Dr. Ujwala Bentale, ma'am, our Vice Principal, Dr. Jyoti Dhar ma'am, and our IQAC Coordinator, Dr. Vidya Dhere ma'am, for their unwavering encouragement and support. Our sincere appreciation also goes to our respected professors, Dr. Advocate Rohit Sarvase sir and Shubham Tripathi sir, for steering this program with such a dedication. A very special note of thanks to our chief guest, Harpreet Singh Kunsal, partner at Sharman Law Office. Sir is a qualified arbitrator, qualified mediator, and CS qualified. Thank you to all our participants for their active involvement, and may the spirit of truth and fairness continue to guide us on this path of victory. I'm also grateful, sir, for this session. We truly fell short of time with how informative this session was. Your approach was practical, and case analysis made the understanding way easier. Thank you, everyone. With this, we conclude day 4 of Saamanjasya. Thank you.
Thank you, everyone. Thank you. Have a
Thank
nice
you, sir.
evening. Thank you to the
Thank
institute and all the faculty. Thank you.
Thank you.
So
Thank you,
much,
sir.
sir. The session was very, very excellent, sir. Thank you so much.
Thank you all. Thank you. I take a leave now. Thank you.